give me a 3, 2, 1, and then take this off. It's live on YouTube. I'll fix it all later in about 30 seconds. And it's on. Okay. So, okay, Chris Hallet with E-Claus. So I wanted to ask you a question, Chris, and before you go ahead and screen share, talking about the remonstrance, talking about tonight, trying to talk about impeachment, or some states call it recalling judges, judges that won't get off our cases, judges that just continue to violate our rights. It shouldn't be terrifying for a family to go into a family court before a judge. That just should never be the case in this country. So I think I really appreciate what you're doing with this whole remonstrance. And this is something that can be taken up by anybody in any state. And I had 2 questions because people don't understand sometimes what it means to have, should the state constitution be ratified or not? And what does that mean?
Okay, well, ratification is the process, the lawful process that brings something into being. Now, knowing that our United States Constitution is the baseline. It's the highest law of the land, but it is the minimum level of due process. So as long as your state's constitution is Republican in character or form, which is Article 4, Section 4 of the U.S. Constitution, okay, meaning that it has all of the characteristics of the Republic, then it can be ratified, which is basically accepted as law. Okay, so once it's properly ratified, that's the only way it can be quote unquote accepted as law, or your state can be admitted to the United States. So this goes back to the origins of the country when they were first building the Republic. And that's one of the reasons why our Republic only has 3 branches or 3 pillars of law. And that each pillar is defined in the process. So pillar number 1, the legislature, the Article 1 branch, is where you petition with your redress of grievances, and that petition is called a remonstrance. Or for somebody who is unlawfully incarcerated, a habeas corpus. And there are various other ones that go along with it, but the general grievance is a remonstrance. So basically the short version is, if the state is not acting in its Republican character or form based on what the United States Constitution says, then you can call into your state assembly. This is what is, when they say First Amendment, your right to peaceably assemble. A lot of people confuse that with standing outside holding a sign. Yes, that's acceptable as long as you do it peacefully. But what that means in the Constitution is your right to write this petition and call them into assembly to address your petition, your grievance. So if you're going to make a constitutional argument, you make those arguments in the constitutional house. That's Congress.
Okay, hold that thought for a second, because this is important. Mm-hmm. So as part of our grievances, mm-hmm. within this petition of remonstrance before our legislative body in our county, correct?
Correct.
Okay, we can go to our assemblymen, because they're over kind of seers of the local legislative body, correct again, right?
Yeah, that is correct.
And within that, we can place our grievances such as impeachment. Is that correct?
Mm-hmm. Here's what impeachment looks like from the federal level. This is a treatise on federal impeachment. So this is the minimum standard. And there is actually I've written mine. My Florida petition of remonstrance is here. But, so basically what we're doing is, and this was actually filed in with the court as well, but because one of the things that I do in commerce is all 3 branches, the Article 1 branch being Congress, the Article 2 branch being the executive, and the Article 3 branch being the court. So everybody gets the same document, just with a different cover page. So this way, nobody can say, oh, this is not a consistent thing. Well, it's the exact same thing. The only difference is the cover page based on the process of your branch of government. So in the state of Florida, the remonstrance being this one, this is why you refer to the joint rules. Now, not all states have joint rules, but the states that do, and you want to call both houses into assembly, and you can say, look, either the Senate's going to take this up and order an investigation, which we'll cover later, pursuant to that process, or we can generate a start the impeachment process in the House of Representatives. Depends on how you guys want to go about it, and you can let them make the decision. Usually what will happen is it'll default to the Senate, especially in cases like ours where there have been investigations conducted and there's no findings of anything. It's all stuff made up. So when you go in and you're wanting to make your grievance in the Article 1 branch, there's the Article 1. These are the sections of that apply within your document. Within these 52 pages, there's references to every one of these these sections in our state's constitution and why it was violated. If there are any particular statutes, because the actors are statutorily bound according to the corporate charter, and in mine, I'm charging them with unauthorized practice of law, and I'm informing them that I'm standing my ground against this. So,
okay, hold that one right there. So now right under pursuant to, in your case, it's Florida, we would put Maryland, New York, whatever, Ohio.
I have an example of Ohio, so I can show you that.
Okay, that's great. But here, like right here where you highlighted 454.23, is that exactly, that's for unlawful practice? I'm sorry. Yeah.
Unauthorized.
Say that again.
Unauthorized.
Yeah, unauthorized practice of law.
Right.
So that's what that is right there, 454.23. That would be Florida, though. We'd have to look at the statute in Ohio or New York or wherever.
Right.
Okay.
Now, because government consists of emoluments, law is emoluments, advantages, profits, and gains, okay? And those three things have to be equal. And we're finding out that they're not. And by reading this book, I found the reference of what the Annals of America refers to as emoluments of statutable plunder. And those are under the United States Constitution, Title 18 U.S. Code 241 and 242, which is conspiracy to deprive rights under color of law, and they're using government money to do it, which is a mismanagement of government funds. That's 643. Now, because that under the U.S. title, Title 28, is counsel's liability for excessive costs. That's what it's referred to. Because I have a license in commerce, I am required mandatory reporting 29 USC 1109 to report those things. So basically, if anything I see going on that looks like hanky panky, technically speaking, because my company and I possess emoluments of my own, an oath of office, and those types of things, I'm statutorily bound to report that.
Okay, let's hold on to that thought then.
Okay.
You are statutorily bound to report that in only the state of Florida, because I have a laundry list of financial hanky panky in the state of New York, thanks to 12 years of advocacy and millions of victims coming to me. What do we do with all that? Like, they don't do the audits when I request them. What do we do with all that?
Well, because I've just built this, okay, and we'd never done it before, the judge issued what's called a standing mandate, okay, which basically defines who stands where in the courtroom based on the arguments that were made. In the case in the 5th District Court of Appeals, the mandate is me versus the government. And the reason it's that way is because the government is a piece of paper. It can't make arguments, if you get what I'm saying. So, and because I'm following the due process of law, the court has taken notice of that and it is written properly, the court honored that grievance. They have no choice because all political power is inherent in the people. Article 1, Section 1. I've claimed and exercised that right. And claim and exercise of a right can't be converted into a crime. That's Miller versus U.S. So what we're talking about, subject matter, is weaponized family court. And because this is actually in addition to previous reporting, that's why it's a supplement. And this is me and who I am, my credentials and everything. And then the principles of practice or maxims of law that are employed in constructing this grievance. This is just how I prepare these petitions. And one of the things that the court recognizes is your commandability of logic, reason, history, language. Those are really the only requirements to practice law. Don't let anybody fool you. So as long as you can show that you have a comprehensive understanding of the basics, starting with history and working your way forward, then they don't have a choice but to hear your grievance. So, now because I have tools in my toolbox that attorneys do not, meaning this license to practice in commerce, well, we know they're using the Commerce Clause to do these things. That's why it's called human trafficking. That's the reason the president wrote the executive order as he did. So now me as a mandatory reporter coming in and saying, hey, pursuant to executive order 13818 on human trafficking, no, you can't do this, period. End of discussion. And this is a standing that has never been employed in this capacity before. Usually it's just a matter of, oh, you got this one saying this and that one saying that. And these attorneys are so arrogant, they don't even comprehend the fact that they are outside of the three pillars of the republic. They're supposed to be registered as foreign agents. They practice in what's called the fourth pillar, okay? Only to exercise good faith, to maintain the integrity of the court, its proceedings, integrity of process, as they, work in the court. And because, this is the same mechanism that inserted itself from the British Accreditation Registry of our association. That's why all these offenses look exactly like the checklist of the Declaration of Independence. So that's the reason that I use that, and that's why I present it that way. So go back to the Texas case.
So, and I also have, if I can just share this real briefly, and then we'll go back to what you have up. Let me just find it real quick. How do I get out of here?
Stop sharing.
Yeah. Okay. But I have, which we already know. Let me just find it. Forgive. Here, let me stop screen sharing for a second, so I don't pull up everything in people's private stuff. But oh gosh, do I have it here or did I take it down? No, there it is. There we go. Okay, let me screen share this. We talked about this earlier today. So, okay, so these attorneys that claim well, these judges that claim that if I go into a court, for example, oh, this is not the right one. Let me just get rid of this. Okay, I'll go to it in a second. Actually, Chris, you can pull this up. You already have this, where they're claiming that they have they're a licensed attorney, and I just did a live on this today. They're claiming that they're a licensed attorney throughout the country. I received something from the chief attorney of the Ulster County Family Court today. She's trying to explain to me where I'm wrong, and then I explained to her where she's very, very wrong. And there you go. And then she was silent after that. And then I went into further at how the court is a fraud and so and so, and how it's just highly dangerous for any of the people that I serve, okay, as an advocate, to go into these family courts, because it should never be a roll of the dice with the protection of your children. And recently, I just went through a bunch of sneaky things going on with the child attorney, the father, And the judge, that's, as you know the story, this judge should be completely off my case, and so should the child attorney.
Sure.
And refuses to get off the case, and now is doing a lot of sneaky things. And so how would you, I mean, obviously this is going to go into this remonstrance.
Mhm.
But like, making up these insane things that my son is playing in the street at 2 o'clock in the morning, and just chipping and chipping. And then I mean, I know attorneys that would never even file something like that because they just would never waste their time, or yours, or the courts for that matter, on
Right.
frivolous stuff like that.
Mhm.
Taxpayers pay for that. We lose work. This is not in the best interest of children, although we know that terminology is
Well,
bogus
it's actually in the bar articles of practice that they're not to bring frivolous lawsuits.
anyway. Right.
So,
I'm aware of that.
mhm.
Okay,
So,
so here you have it. The practice of law cannot be licensed by any state. State Worcestershire versus Board of Bar Examiners, United States Reports 353 U.S. Pages 238 to 39, in Sims versus Ahern. And this is what I did in my live earlier today, because she used something else. Matter of fact, let me go get it so I can at least read it. Just give me 1 minute while you can continue talking since it's live.
sure. Yeah, basically a bar card is not a license. It's a dues card or a membership card. A bar association is what it is. Club. An association is not a license. It is a certification through the state. The two are not the same. I have another card similar to this one called ASE certification, automotive service level, or automotive service excellence. It as well as registered with the state. It's what is required. It's the standard in automotive parts service and the automotive industry. So knowing and understanding what the bar association is trying to claim. Well,
but it's the British.
It's a foreign entity. That's why they have to register as foreign agents.
That's why they need to register as foreign agents. So okay. So this was, I'm saying, I said it wrong actually. She's actually the principal court attorney, and so she sent me this letter. And basically, what she used against this right here that you just seen, because I sent that into the court, or I want to call it a court. We know better.
Right.
Basically, she sent me New York, and you want to look this up. Judiciary Law Section 478. That was her argument. And when I went over it with her, including a bunch of other things, and she was a very nice woman, and I don't want to like expose her name or anything like that at this time. I would love to continue having a conversation with her because we need our families protected. And I said, and we need our families protected in this community. We have a moral obligation to that as human beings. And basically, I read the letter on the live today. You guys can go back and watch the video if you missed it. You really would want to see it. I kept it very short. But where do we go with that? And the fact that I am impeaching Anthony McGinty. I'm in the process of it. I'm doing exactly in the proper order. I've got over 200 victims that have come to me that are his direct victims. Where do we go from here, Chris? Where do we go from here?
Okay, so in your petition of remonstrance, let me bring this back up again. Let me go back to the Texas case. So this is a good example. Because of the situation in this particular case, here we are again, Texas mandatory reporting law. Okay. This is the state's equivalent of counsel's liability for excessive costs. So that these two things are Republican in character or form. We also have an order dismissing the case from 2016, but they've been trying to keep it going. Title VII offenses against property, which is the state's version of the Hobbs Act. And then we have this 84th congressional action establishing the emoluments of this particular court, which are defective. And I'm going to show you those, and I'm going to show you why they're defective. So that's this order right here. Now, in order to conform to the 10 principles of group decision making, constitutional provisions are mandatory. Well, according to this order, the District Court of Ector County, Texas, will formulate an appropriate strategy and method to effectuate the intent of the 446 Judicial Court's designation. Here's our grievance. Who decides what the appropriate strategy and method to effectuate the intent is? Where did this come from? Who made this decision? Because in order to be constitutional, in order to conform to the 10th principle, the 10 principles. In the 10th principle specifically states constitutional provisions are mandatory. So because this order was defective, they have to go back through and audit every one of the cases since the inception of this emolument, signed on the 7th day of 2015. And because of that, we got 1,250 cases dismissed in one day. See how that works? So
I know, and I was excited and jumping for joy over that. It was absolutely amazing.
right.
And we want, so now we're going to.
Now what you're going to do is you're going to take this, you're going to take the oath of office. I sent you the acknowledgement form.
Yes.
And in this process here, the Treaty on Federal Impeachments, this is the minimum standard. Okay. And we're going to run down through some of the basics here. Guess where this came from? New York Public Library.
I love it. I love it. And I think I'm going to present this to the court and CC it to everyone in the court. And I'm actually going to make sure this goes on the record, this exact video.
Right.
That's I'm going to use it in my book, because see, my book has their names in it.
Oh,
and yet he still won't remove himself from the case, even though I'm suing him, even though we know that's a joke. But all the rest is that we're doing is powerful. And they continue to just sneak behind the back door and violate my rights every day and my child's safety every day. And I've had it. And I'm so public and everybody knows my case. The county itself was embarrassed by Anthony McGinty because of what he did to me and my son.
Right. So as a writer, I'm going to share something and you'll get a kick out of this. In the beginning of every publication is what's called a preface, right? In the beginning of every remonstrance I write is also a preface. So you see what I'm saying? Following the established format, okay, this remonstrance was actually written under what's called a brief on the merits, came from the state of Texas Superior Court, or Supreme Court. So they can't say, oh, your format is incorrect. Well, go through your rules, and I guarantee you when you check that out, you're going to find that's incorrect. So again, because we followed the due process, we even picked a format recognized by the court, there was no way they could say no. So I said we backed them into a corner. So,
right. And as you know, we will all be speaking to them coming very soon. So I'm sure you're very aware of what's happening in the very near future. Sure. And the target is many courts, but specifically Ulster County.
Right. So we get through the preface here and we get into, federal impeachments. You starts basically go over the criteria. You see them in this type of thing, and governors of states. Let's see. There was one federal impeachments. Yeah. See, we're going into good behavior. Is the one for judges. I had it pulled up here for a while. Let's see. Jurisdiction of the Supreme Court shall extend to the trial of impeachments of officers of the United States. In case of impeachment, jurisdiction shall be original. So now, excuse me, because again, going back to the due process clause of the original Constitution, when you prepare your remonstrance and you put cover pages on it to go to all three branches, okay, and if the state Supreme Court declines to hear the impeachment, then that means they forego or forfeit jurisdiction. In other words, they can't claim a right to a cause of action pursuant to this article here, which is what they try to do an awful lot. And because remember, silence is acquiescence. So if you're not going to respond, then we're going to handle it back in the Article 1 branch. And that's basically how I've proceeded in Washington, D.C., because Washington, D.C. is basically kind of give you the idea, kind of give you the skinny and the lowdown, is they want this crap shut down as much as we do. And they're, you know what? They're like, you know what? You guys are absolutely correct.
Of course we are.
Well, the fact that you guys have done so much homework, and you're, for example, the one chief of staff looked at this document from Texas, and even came directly from the state senator, and he said, I've been practicing law for 11 years, and you are way over my head. I completely don't even understand this. And the judge is like, yeah, we understand it, and you're going to do it. So, exactly. And one of the reasons that we know that they're doing it was those 1,250 case dismissals in one day. And, it's now that they know and understand that this is actual due process of law. I mean, in like take Kirks' case, for example, there's never been a petition of remonstrance in Idaho. It's never happened. So we're talking processes that haven't been used in 100 years because everybody's been so brainwashed into believing, oh, just hire an attorney and let the attorney do it. Well, we know how that turns out. They milk you and milk you and milk you. So when you pick up that torch of liberty and you start doing this on your own, now everybody's nervous because it was like, hey, tried to do this in the court and all you guys did was want to laugh and pull your arrogant crap and think that, you're all this and you're all that. Well, now when we get into Congress and congressional members are having the same problems that we're having, and now you want to cry foul, tough. Basically the short version. And even the judges are going, yeah, right, tough. So, if it's a choice between them or us, or them or the bad actors, I guarantee you they're going to pick the bad actors any day of the week, twice on Sunday. And, it's a means to an end for the judges because they're sick and tired of having to make the same arguments over and over and over again, just to come to the same conclusion. Quit using the Commerce Clause to build these fake jurisdictions, and I'm going to show you what that looks like. Oops. Here's an example of those emoluments of statutable plunder. This is Title IV from the Social Security Act. This is what I refer to as an emolument scam. Governed by guidance policy documents, statutes, codes, rules, and regulations, and other such word salad. So knowing that the word emoluments consists of three component parts: advantages, profits, and gains. Well, the advantage is the fake jurisdiction that they're forcing. Somebody says, I need a law. You want to say, no, what you need is due process of law. You don't need a law.
Right. So, which they pretend they do, but they don't really do.
That's correct. And one of the things, that many of us have been improperly trained to believe is that domestic violence is a judicial argument. It's not. It's a political argument.
Right.
So in cases where
there's a war, isn't it a war violence? Or
that's exactly right. Domestic violence is an attempt to overthrow the government.
And when real violence takes place in a real family, when somebody hurts another person and repeatedly does, and the court keeps giving them carte blanche to do that, why does family court has no jurisdiction over that, and yet they still take it?
The reason is because they know they have no jurisdiction over domestic violence.
Well, they have no jurisdiction over anything, actually, if you really want to get real.
Technically speaking, you're correct, because that's not a proper process.
Right.
That's between this fourth and fifth pillar of this title. That's where it's outside of the three pillars of the Republic. This jurisdiction is foreign to our form of government.
There you go.
When you go back and you read the Declaration of Independence, you can say, yeah, this is what we're talking about in the Declaration of Independence. It's foreign to our government, unacknowledged by our laws. We don't acknowledge the fourth and the fifth pillar. We know they're out there, but it's not a lawful jurisdiction. See what I'm saying? So
I do. I don't normally talk about my own personal case. I'm always talking about everybody else's and helping them with their cases. But because this is fresh on my mind right now, and I'm actually going to take this video and I'm literally going to file it into the fake court of record that they have in the family court in all parties. I'm going to use this as evidence against them. Congress is on my case, okay? And so by name. So I asked him for his oath of office, and he told me to go to New York City for it. Because I said to him, I don't know where I am. Not that I was Lucille Ball. I didn't know where I was. Where am I? Who am I? I said, I don't know where I am. I don't know who you are. I don't really know what your job is, even though I've been here for a million years.
Right.
Okay. And the previous judge was Mizell, and she recused when I reported her. At least she had the decency to recuse. And, then I got this dude. And, prior to even having him, I was doing rallies for reform, and I was on the news. I was in the newspaper, and my name was speaking against his name. So he should have never been my judge. And then directly after 70 cases of child abuse, reporting it to the Committee on Judicial Conduct, which we know is a private agency that works for the unified court system. So they're quote unquote private and public, which makes no sense. They said that these judges did fine, even though there was all this abuse to children, and they were ordering parents to put them into the hands of abuse.
Right.
But when I asked him for that oath of office and he never gave it to me, shouldn't most judges run off the bench at that point? He arrogantly sat there. What's the deal with that? Chances
are he had no clue what you're talking about. Seriously, I see that a lot. And for example, one of the reasons that, people started to take notice of my company is because I employ maxims of law, those fundamental principles. And there's 2 of them here at the top and the bottom. 5 pillars of law being not Republican in character or form, and I'm not even going to dignify what character or form that is by calling it what it is. It is a cursed construction that corrupts the text. And according to our ideology, right, it's that 5 pillars is the cursed construction. And what is illegal ought not be entered under the pretext of legality. In other words, you should know that. There's even another maxim that states, to know something and to be bound to know it are regarded in law as equivalent. So anyway, we go back to what this does and what I mean by the Sestke trust bonds. That's these Social Security where every time they open a case, they create these bonds. Okay. Now, all we see is the court fees and the attorney's fees that we pay. That's all we see. They're extorting the Social Security fund 5 ways from Sunday, just in this particular model alone. Lord knows how many other ways, pursuant to the statutes, codes, rules, regulations, and other such word salad. That's the reason I put it there. So just because we're talking about the word emoluments scam, because government is emoluments and Social Security is an emolument. So it's not an entitlement. Sorry, folks. Hate to be the bearer of bad news, but that's just the way it is. That's the law. So that's why we end up with this negative nexus between this 4th and 5th pillar, because it's outside of our form of government. And again, there's 2 principles or maxims of law that actually construct this algebraic expression, and it's how they're getting away with it. So it's, because one of the things that I used to do in my life beforehand was I used to construct business models like this. We always stayed away from stuff like this because we knew darn well we'd have had our rear ends hung by a yardarm if we'd ever tried to pull a stunt like this. So, these are things that we knew, don't even go anywhere near stuff like that. Get in all kinds of trouble. So basically, Chris, and then, obviously we can open up to questions at the end, but basically when we know that these family courts are not a court of record, right? But then they claim that they are. So that would literally be a contradiction to, how do I explain it? I'm not finding the right words, but in reality, okay. So we know that they'd have to admit it, that it would be under common law at that point if it was a court of record. Therefore, everything that they're saying, we would literally have complete power over them. Well, and again, because they're outside, they're not in the common law, they're in the private, right? Correct. I understand that. But what I'm saying is, if they were to say we are a court of record, which they claim they are, but we know they're not. So in other words, I guess what I'm trying to say is that it's always a contradiction. Well, what you say at that point is you say objection. Some counsel or judge is attempting to enter facts that are not in evidence. Okay. Okay. That's a proper objection when you're talking about actual litigation. Which makes it appealable. Correct. So, again, you have to, voice your objections, voice your grievances, those types of things. And of course, they know objection overruled, blah, 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 and they get really arrogant, as they always do. So I'll give you an example, and you're 100% right, and that's an awesome thing. And anybody that just came in should definitely understand that your First Amendment right
quote unquote freedom of speech, freedom to assemble, people think it's just coming in front of the court, the fake court, but coming in front and peaceably, you know, protesting or whatever. However, it's not. It's actually, I mean, it is, but it's this bringing together your legislative body and making them do their job. Basically, they have to do their job because they are our employees. But at the same time, now when I do have protesting, and various advocates do that in front of these buildings, they'll tell you to step back several feet off the property. And I'll say no, because I own this property. And then they don't argue with me. They usually let me stand there. Right. Once I explain to these police officers, because obviously they're just pretty much, and I don't say this disrespectfully because a lot of these guys are nice guys, but they're monkeys of the court or puppets of the court, of the building, I should say the building. But in reality then, if it's a private, which we know, private for profit business, okay? But if it's private and we're not allowed inside to protest, which we should be, no different than we're allowed outside. Or up against the wall, or inside the courtrooms.
Yeah, so then the question becomes, where is there standing in law to conduct this business and violate, you know, your rights, whether they come from God or whether they come from wherever you believe they come from. And again, this is the argument that we used in this particular case, where I constructed and I actually ran through and broke this down using calculus. But there's those two maxims of law. Remember, going back to how can you construct something? Are you capable of conscious thought? So this is how you do that. You know, obviously it's got a name. It's based on these two principles. Here's these two constitutional articles. Article 4, Section 4, Republican form of government. And as a mandatory reporter, I'm here to report on that. Okay. Article 1, Section 9, Clause 8, the emoluments clause, that defective business practice that I just showed you, counsel's liability for excessive costs. So that's the reason that these two maxims of law go with these two constitutional articles in context as you proceed down through the argument. And because, you know, it literally ends in, you know, basically judicial estoppel, pointing out that, oh yeah, this is not even a proper forum because we already have, according to the cover page, we already have an order dismissing without prejudice from December 14th of 2016. So even the court recognized that it was not the proper jurisdiction. So, you know, point is now that we have a mess to clean up, hey, we're here to clean up a mess. And because Congress is the only one who can either enact or remove an emolument of any form, any advantage, profit, or gain, and that includes any matter that's a result of that emolument, it has to go through the Article 1 branch first. So, you know, part of the relief and remedy that we requested was, oh, by the way, yeah, you got to clear dad's name, you know, and all of, you know, you got bad actors that you need to deal with, and that's the 10 principles of group decision making, and here's his grievances, 10 of them. And so, you know, follow the due process of law. Here's the due process, and this is where it comes from, based on these 10 principles, even describing what the quorum is, where it comes from in parliamentary law. And here's your 10 criteria that you need to go over in this quorum. So, you know, again, this is in the private sector, we call these reports. This was a loss prevention report from, you know, just the way I always did business in the private sector. Well, when I figured out that this is due process of law, it's like, oh man, okay, I think I know exactly what I need to do. Boy, I'm going to make a lot of people mad with this one.
Mm-hmm. Well, sure, you're taking it right out of their pocketbooks, but
so that's the end result.
And it's really sad that children, you know, don't matter to any of these people.
Right.
Now, of course, I said I was going to ask questions that were dumb questions because they're not really dumb questions, but because for people that, you know, just coming in on this, just learning, or, you know, maybe some people are super seasoned. But so basically what this means is that anytime we walk into one of these buildings, right, Well, I love the ones that say, don't talk about the Constitution here, even though they say they have an oath to the Constitution, but don't talk about the Constitution here because we don't run under the Constitution. And of course I say, so you're telling me basically when I walked into the building, I just got off of American soil, and they're just looking at you like, and literally these attorneys all over will tell you this. They'll tell you not to use a constitutional argument because this court does not operate under the Constitution. So Malika, made a very good point. She said, then that would mean that you'd have to take your gun out. And I'm not telling anybody to do this.
Right.
Basically, you'd have to have self-defense on that matter because you are being held hostage and in bondage.
That's
correct?
right. That's right.
And our police are completely deceived. Completely.
Yeah, ignorance of the law. So much for excuses on that one. And again, as I explain this, basically what you're talking about when they tell you you can't make an appropriate argument, that's an obstruction of the administration of justice by refusing his assent to laws established for the judiciary powers, right? Because the Constitution does have provisions that provide for the administration and an assent of judiciary powers. So, it's an oxymoron and a major contradiction. When we're talking about CPS and these alphabet soup agencies, here it is right here. He's erected multiple new offices, sent hither swarms of officers to harass our people and get out their substance.
Absolutely.
This is not a constitutional argument. This is a Declaration of Independence argument. Mm-hmm. Okay, you don't want to make constitutional arguments. I'll make Declaration of Independence arguments and fix your wagon. So,
and I love what they say that they're not. CPS is not an arm of the court, and yet they are. They are exactly that. Matter of fact, they're now, and because this is not just every court that I've been visiting, every court that I've been court watching, they're now all moving into the same buildings now. They're all coming together. So you've got DSS or CPS, Child Predator Services, right? Family Circus, and then you've got the welfare department, all in the same thing. So they're the elder abuse and child abuse all together. And then obviously they go by Child Protective Services, which we know is the complete opposite. But if you protect your children and you go into a family court right away, you're the villain. You've done the wrong thing. But yet, you talk about a contradiction and a conundrum. It's what is Child Protective Services for? Although we know they don't protect children,
right?
So what is?
They're not in the defense and they're not in the Commerce Clause. Right. Then they are outside of our style and form of government. That would mean he has kept among us in times of peace standing armies without the consent of our legislatures, and that because we're the people, that's us. He has affected to render the military, because if they're claiming their protections, then that means they're military. He has affected to render military independent of superior civil power. Can't do that. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their pretended acts of legislation. Mm-hmm. So they're acts of pretended legislation. That's exactly what they're doing. That last one is when they say don't make a constitutional argument and you go in and you make a Declaration of Independence argument and you point out exactly that you know what they're doing. Mm-hmm. So I said they're stuck.
Well, I did a legislative address to impeach Anthony McGinty, and everybody has it. The whole entire legislative body and all the assembly people in the Senate and much higher too, without saying who. But I know that I'm doing it in the proper order, and every last one of them says he should have got off your case a long time ago. They all say that. So, but he continues to sit there, which doesn't make him look good because he's already been under deep scrutiny. My last question, and I'm going to end it with this, and then open it to others, is this: when there are quote unquote laws, of crimes that are in our states, and these judges order you to literally violate the law. That's what they're doing. And I've talked about this before. In New York, I know it as Penal Code 26010, when you knowingly and willingly send your child into abuse, some type of an abusive situation, and you do it knowingly and willingly. Okay. Right. Now, most normal parents are not going to put their children into some kind of harm's way, whether it's a biological family member or a non-biological, and that's common sense. You're not going to, if you walk into a daycare with your baby and the person is sitting there, shooting up heroin, that ain't going to be the daycare for you. Right. So why would the person to babysat your family child or whatever in your family? Okay. Common sense. But a judge, and repeatedly, all over this country orders parents to do that, orders them to do that. And then on the other hand, you'll see them fighting against somebody that does that. And like, in other words, it's never the same bowl of soup in all the restaurants, you know?
Right.
So how is this remonstrance handle something like that when parents don't want to be forced to A, hurt their kids, and B, violate the law?
I'm glad you brought that up. Let me go back here. I'm going to pull something up here real fast. Because you just brought up something that I wanted to point out. And as soon as it opens, here we are. This is where you're going into ideology. Here's the ideology. So when we talk about the 5 pillars, when you go in and you assume your standing as they are committing political acts of domestic violence against you, basically, using this Violence Against Women Act, and it's violence against women and children through the Adoption and Safe Families Act, because we know that's what Title 4E is all about. So this is the foreign ideology, and you're just going to call them to the mat on it. So, you know, and that's why I said it's a matter of when we go back to the Declaration of Independence. Let me see here. One of my favorite declared acts of tyranny.
Hey, Chris, this is Slavin. Do you mind? A lot of people don't even know